Well, welcome to this Friday afternoon webinar. Hope you're all doing well. For those of you who have never attended a legal services webinar before, again, welcome. But I will. We usually start them about 5 minutes early, and really that's so everyone has a chance to get their audio, get their visual. Almost everybody who signs up does, the first time has to work something out. Couple of things I'll mention, and I'll say it again right before we get started. If you have problems during the presentation, there's a box on the right-hand side that you can ask any questions. It says questions. That's for the presenters, and that's also if you have any audio or visual problems. And what I'll do with the questions for the presenters is I will, like when they stop at an appropriate time, when they stop talking, I will go ahead and ask your questions. So please be patient. I know last week we had a lot of questions, and it was part of the presentation. It was down the line, so we just kind of got to let them talk about everything, get it all in order, and we'll get your questions in before the end. We have still a few minutes, so a little bit about legal services. Legal services is the statewide provider of free legal services to low-income people in Alabama. There are about 1 million low-income people who qualify for our services across the state. Obviously, we can't help all of those folks, which is why we always encourage people attending these to volunteer. You can do that in one of two ways these days. And the number one way, the traditional way, is to volunteer with your local pro bono, your volunteer lawyer program. If you don't know, there are 5 volunteer lawyer programs in the state of Alabama. 4 in Montgomery, Mobile, Huntsville, and Birmingham, and then one more program that covers the whole state. You can find out which one you would belong to, and I think you can even volunteer for more than one if you choose, by going to the State Bar's website and signing up, and they will get you in contact with the people you need. The second option, the Alabama Legal Answers, which is a new way to volunteer, is sponsored by the American Bar Association. And it would let people take low-income people again, ask questions, and they'll be emailed to you, and you can basically answer them at your leisure. Someone in Birmingham can answer a question for someone in Wilcox County. So it's a great way to help people, and also to create some sort of geographic equity, since the big VLPs tend to be in the big cities. Again, Mike Fortin, Director of Advocacy here at Legal Services. Very glad you've joined us. It's about 12 o'clock, so that one more time I will tell you, if you signed up for the webinar and you put your bar number in, and you sit through the whole presentation, you will get your CLE credit. There is nothing else for you to do. At least 5 people listening to this will still email me and ask, and I will tell them again. If you signed up, if you did everything you had to do to register, then you are good to go. And you will get your credit. It'll probably appear in a couple of weeks. I don't know what the bar is doing in terms of a shutdown, so it may not appear as quick as normal, but it will be there. And then the second thing I always get questions on is, how can you talk during the webinar, and you really can't speak, but you can type a question in questions, and then we will get those on to the presenters as they're talking. Same thing with audio or visual problems. And I see some people are typing already, so I'm guessing you may have some questions. With that being said, I'm going to turn it over to Ms. Sarah Taggart and Ms. Holly Ray, who are going to present to you on the state of housing in Alabama during this COVID-19 crisis. So one second. And you're live.
Hi, everyone. I'm Holly Ray. I'm the managing attorney in the Huntsville office of Legal Services Alabama, and the vast majority of my practice is based off housing law, helping people stay in their homes, whether those are rented or owned. I'm here with my friend, socially distanced, so you won't see us on the screen at the same time, Sarah Taggart. Sarah is exclusively a landlord representative attorney here in Huntsville. Hi, Sarah. As you can probably imagine, both of us have our phones blowing up with landlords and tenants calling to ask questions, as COVID-19 has dramatically changed life from the way it looked a month ago for most folks in Alabama. So today we're going to go through and answer the most common questions that I've received from tenants, the most common questions that Sarah has received from landlords. We're going to answer those to the best of our ability. I always give the warning with these, man, COVID-19 is a moving target. Every time we think we have an answer, we get a new piece of legislation, we get a new moratorium. We get something else that comes out that may change this landscape a little bit. Most of the things that you'll see coming out from my office and from Sarah's will give you a date on them that they're current as of, because information rapidly changes. So we're giving you the best information we have as of April 3rd at noon. We are going to try to give a statewide overview. Alabama has 67 counties. That can make it difficult because every county is handling this crisis a little bit differently. Feel free to chime in the questions box if information that we're giving has been adjusted a little bit in your county. And as always, we're going to answer the most frequent questions. Please ask your questions too. We're going to answer them to the best of our ability. The most common, if you can flip the switch, Mike. The most common question we're getting from tenants is, do I still have to pay my rent? They're seeing stuff on the news about eviction moratoriums in other areas of the country. They're seeing Donald Trump on the news, President Trump saying, we're going to moratorium evictions. There is no national eviction moratorium that covers everyone. Nothing nationwide. There is no statewide eviction moratorium in the state of Alabama. So in general, there is no eviction moratorium. Your rent is still due and owing. Most leases are due on the 1st, late after the 5th. We're sitting here on the 3rd of the month. Your April rent is still due if you haven't paid it. Nothing changes that. The next question we get, as you can imagine, Alabama saw a spike in unemployment applications last week to an amount that we haven't seen since 1986, when some people on this webinar might not have been alive. As a result, a lot of people are asking us what happens if they can't pay their rent. I'm going to do my best to answer that from a couple of different angles from the point of a housing advocate. The CARES Act does provide some relief. Obviously, there are stimulus payments going out to a lot of people, $1,200 for most adults, $500 for qualifying dependents. That should be your front line of defense to pay your rent if you're having financial difficulties. We know that unemployment has been difficult to get through the system to apply. I believe last week 77,000 people applied. We believe that number may be artificially low simply because the system has been down for large portions of time. Applying for unemployment through the extended benefits through the federal system should also help you be able to preserve your housing while we wait for this to blow over and life to return to whatever normal will look like after this. We will, in a bit, go into the eviction moratoriums that do apply under the CARES Act. I'm just going to quote the act at you. I think what Sarah and I have kind of decided to do is I'm going to tell you what we believe the act reads at Legal Services Alabama, what the groups that support us, like the National Housing Law Project, have read, and what their description of the law as written tells us. As you might imagine, groups like the National Apartment Association have some disagreement on certain areas of that act. So we're going to talk a little bit about where those disagreements may come up, how they affect landlords, how they affect tenants. But again, I can't impress enough, there is no nationwide and no statewide eviction moratorium. There are moratoriums that apply to very certain specific sects of the landlord-tenant population, and we're going to go through the CARES Act and where the pitfalls come in at. A lot of the calls that I've gotten at Legal Services and what I imagine attorneys around the state are getting are folks who have never had to access the social safety net before, folks who have never had this problem, folks who have never been out of a job, and all of a sudden a retail place they've worked at for 20 years has closed due to a government order, and they don't know what to do, where to turn. For immediate assistance, things like food, things like utility assistance, things like medicine, your best bet is to call 211. That is a national system. It is certainly a statewide system. It's going to put you in touch with the United Way in your area to help you find those immediate services. The emergency budgeting advice I've given to clients since I started at Legal Services during the Great Recession has always been, when you're looking at the pot of money you have in front of you and realize that you can't pay it all, I want you to pay your medicine first. If there's a medicine that you stay on that sustains you or a member of your household's life or sanity, make sure that you're covering that med first. You're no good to anybody if you're dead. You're no good to anybody if you're in the psych ward in terms of paying your rent. The second thing is food. You know, that beans and rice type budget. This is the time where we're seeing free school lunches for kids. This is the time where we're seeing food pantries. We want you to be fed. We want you to have your meds. After that, your rent should be the next bill that you look at paying out of your available funds. Many landlords, for obvious reasons, under normal situations, are not going to take a partial payment of your rent. They need the full amount due. That's what your contract signed. You agreed that you would pay your full amount of rent. They agreed that they'd provide the roof over your head. These are not normal times. So we do see a lot of landlords, and Sarah will touch on this, being willing during this immediate emergency to accept partial payments. There will likely be a contract or something that you will need to sign that you understand and acknowledge that this is a waiver of the normal policy, that they are accepting this due to the temporary hardship that's befallen a large portion of our society. The other thing I tell tenants is a lot of people who this is the first time that they're having to access the social safety net, they're feeling a lot of shame. They're not wanting to communicate with their landlord or with the people that they do business with about the hardship that they're having. Communication is key. This is a problem that is through no one's fault. I don't think anybody listening to this webinar or any client in Alabama ate the bat in Wuhan or whatever started this thing. This is out of all of our hands and all of our control. How we react to it and hold each other up defines who we are. Communicating with your landlord now, telling them what's going on, telling them that you've applied for unemployment, telling them that as soon as this stimulus money comes in, I'm going to pay my rent for April. Keeping that line of communication open is key.
Well, and the one thing I will say for the 5 people who have asked, I did not put the handout in the section that you can download it. I will send the handout after the presentation is done. So I'm not going to respond to all 5 of you, but trust me, you will get a copy of the handout.
All right. The next question that we're getting, both Sarah and I, is the current status of evictions in the state of Alabama. What happens to ongoing cases? What happens with filing new cases? The courts were closed until April 16th. We got an order 2 days ago that extended that through April 30th. Evictions are not considered essential or emergency hearings. I don't think there is a county doing them by video. So right now the courts are closed through at least April 30th for in-person hearings. County by county, evictions that were set before all of this began, cases that were filed in February and March. Most courts don't seem to be granting continuances or resetting them right now. That's just because they don't know when they could reset them to. Feel free to chime in if your county is handling them differently, but at least in my 13 counties here in North Alabama, we're not seeing continuance orders yet. We're just banked with the knowledge that once things change, we'll see those court dates set. We've heard stories through the grapevines where tenants are kind of taunting their landlord and saying, you can't evict me. That's not true. A landlord can still file an eviction. Most landlords have attorneys. Attorneys are fully vested with the ability to file online. Our file has stayed up through this whole nightmare. Sarah could go file an eviction against you today if she wanted to. Your landlord can still file. So if you don't pay your rent, you may have the concern of an eviction being filed against you. Additionally, if your eviction is for something other than non-payment of rent, now is not the time to bring in a stray cat if your lease says that you can't have pets. If you have had to bring in an additional house member who would ordinarily be violating the guest provision of your lease, now is the time to either consider if that's a wise decision, or depending on the situation, talk with your landlord and let them know what's happened. I know we've gotten a few calls about grandmothers who are having to care for grandchildren because their parents work in healthcare, and it's not safe to have the kids at home during the quarantine, or the kids are out of school and there's no one else to care for the kids in a family where dad is a doctor and mom's a nurse, so they're temporarily in grandma's apartment. Don't hide these kids and assume no one is going to see them. Be honest about it. I think most landlords are going to be understanding, and I think Sarah can chime in on that to the extent that they can be. We know that we are starting to see a ratchet up in noise complaints. And to be honest, I don't think we've ever had an event like this where everybody is at home. Most people who are at home may be trying to work from home. Their kids are at home and they're trying to crisis homeschool them at home. For people in close quarters in apartments, I can see how that would become incredibly annoying, incredibly fast. You know, my advice to folks has been real life happens, but let's be mindful of the noise. Now is not the time for loud TV. Now is not the time for loud music. So evictions for non-payment of rent, for everything else, for violation of lease rules are still there. Don't do drugs in your apartment. That's always going to be my advice, but especially right now. Anything other than non-payment of rent is not going to get you around the CARES Act provisions that we'll talk about that do produce that limited eviction moratorium.
So, and you represent people in all of the state, right, Sarah?
Yes.
So what is your experience with the current status of evictions in and around the state?
Most filings are in limbo. The filings that you do in sort of the middle areas, Jefferson, you file it and you get an order saying nothing is going to happen, no defaults will be able to be entered until the court system reopens. You know, I've been filing, not as much as normal, but I certainly have been, especially for arrearages, and we'll talk about this a little bit later when it's my turn on whether, you know, what sort of judgment you should use on who to file on and who not to. I've been filing and they're just sort of sitting there. And I agree with Holly, you know, I had 30 something cases set right before the courts closed. I've received no information from the bench on what they're going to do with those or how they're going to choose how to reset these things. A lot of courts set their dockets at the first of the year. Are we going to add dockets? It's just right now, a lot of things are in limbo.
Are there any courts where they are going forward?
So I believe the Madison County Sheriff's Department was doing setouts until I've lost track of days, but it was after the courts were closed that they were still doing setouts. I have not tried to file a default because I believe that if the courthouses are closed, it limits a tenant's ability to answer, and if you get a judgment, I think that it would be subject to being void, and you would have difficulties if you try to execute on a judgment that could be subject to being void. That's just been my sort of interpretation of where we are right now. I do know that some landlord attorneys that file on behalf of landlords are filing defaults, and I'm not sure if those defaults are getting granted or not. But I would be very concerned about the status of those orders.
Oh, and I will say that one attorney in Jefferson County said that the sheriff there told them there's a national moratorium on eviction, so we're not doing setouts. I informed them that is not correct, and they said they're still not doing setouts.
I mean, but that's also that particular sheriff's department. that does not surprise me at all. And, you know, I was a little surprised that some of them were doing setouts as long as they were. But I believe that most clerk's offices aren't issuing new writs to the sheriff. So even if you did have a sheriff that was willing to do a set out right now, it's sort of going to only be the writs that they had before this all happened.
We know that Montgomery County is still serving new unlawful detainers. They're still serving out the lawsuits for people that are filing. I know there's one kind of rogue lawyer down there who said the federal government can't do anything to you. And so he's still filing, and apparently they're still being served.
I mean, I've always used process servers.
Yeah, so
until we go to shelter in place,
they can be served.
They can be served. They can be filed and served, but then they're kind of just out there.
Which leads to the next question. If you or a client that is calling you has been served with an eviction, what happens next? This is another case where we have 67 counties in Alabama, and they're all handling everything a little bit differently. Most Alabama counties are under the status of what we call closed but still staff present, which means that there may or may not be someone in the clerk's office in that staff, and they may or may not be processing documents. That is very patchwork and piecemeal across the 67 counties, across the 13 counties that my office covers. We've had varying answers over the course of this thing as it has developed. So our party line at Legal Services has been out of an abundance of caution. We do not believe that legally you must file an answer within 7 days while the courthouse is closed to the public. But if your courthouse is accepting answers out of an abundance of caution, file within the 7 days after being served. And that's 7 calendar days, not business days. Every county is handling this a little bit differently. In Madison County, they're telling tenants to mail them in. As far as I can tell, they're not being opened or processed. People that I know have mailed in an answer, and I know the date that they mailed it in, are not getting their answer entered into the system. There are a handful of people who sent it by certified mail, and they're not getting that return postcard that you get with certified mail. In other counties, like Limestone County, their courthouse is closed to the public, but you can drop your answer off with the security on the ground floor. Morgan County has a drop box where you can drop things off outside. Every county is handling this a little bit differently. We don't want people harmed because they didn't file an answer within the 7 days. So our answer has been mail in your answer or call your county clerk's office and try to find out how to get an answer in if they're requiring it. Some counties are telling us they're not doing anything with them right now, and in that case, we've got a little bit of time to play with. Additionally, attorneys are always able to file an answer electronically. That's an individual decision on each case as to whether or not, in that 5-minute phone call, I can represent this person or tell them to mail in their answer. I've certainly filed more than my fair share of electronic answers in the past few days out of an abundance of care. If you believe that you are eligible for the federal moratoriums, that needs to be raised in your answer. Not all tenants that are pro se on their own are going to know how to do that, but if you're an attorney filing answers for people, you certainly need to, if you have the inkling that they may be subject to the moratorium, file to dismiss the case and state the act. If you don't answer the lawsuit in time, this, under normal circumstances, obviously, if you didn't answer within 7 days, you would be subject to a default. That default could lead to a writ that would set you out. Much like everything else is stalled right now, I personally have not seen a default in any evictions in any of our counties. Sarah, have you seen any defaults granted?
I'm not, as I mentioned earlier, on the new cases that I'm filing in, I think they'd be void, so I'm not risking that.
Yeah, we don't have any statewide guidance that tells us whether these statutes of limitation to answer are told, which is part of why we're telling people out of an abundance of caution, make sure you file your answer. If you have any questions about this kind of patchwork of county closures that we're seeing around the state, I put in alabamacounties.org/coronavirus. Is basically a list of every county in the state and the status of its courthouse as far as just being open to the public for, whether you were filing an answer, filing something with the clerk, or going to renew your car tag. The vast majority of these counties, with a handful of very rural exceptions, are saying that they are closed to the public but have staff present. That seems to be the state of a lot of things. That's the state of us at Legal Services. Our lobbies are closed, but we are all here working full time. You can also visit the State Bar's coronavirus website, and it will have some additional information about various court orders that have kicked in.
And Sarah, we do have 2 questions. The first one should go pretty fast. Somebody's asking for you to distinguish between what's an eviction versus what's a set out.
Okay, so an eviction, that's actually, I have always philosophically asked, when is somebody evicted? And I never thought that it would actually matter, but now it does. When I say that you can still be evicted, it means that I can file and serve a complaint, an unlawful detainer complaint. When I talk about a tenant being set out, it means the execution of the writ of possession that comes at the end of the eviction or unlawful detainer process. That's when the sheriff goes to physically remove the tenant or resident from the property.
And the second question is, what do you think are happening to the evictions that are filed? Do you think that the sheriff and the clerk are just going to hold them and process them once it's all over?
I really have no inside information on how they're going to deal with the mechanics of reopening the court system. Logically, it would be that they process them in the order in which they've been received. Judges are probably going to have to look at adding cases to their existing dockets. This is actually a really interesting question. Are the cases that I filed before the CARES Act subject to the CARES Act? If I don't have a judgment, these are all questions that hopefully we'll get further guidance on from the court system or the federal government.
So digging in a little bit deeper into the CARES Act eviction moratorium, and I couldn't figure out a better way to do this than give people block text. The eviction moratorium that's created by the CARES Act, which is kind of the federal omnibus that a lot of this is coming out of, restricts landlords from certain covered properties from filing new eviction actions for non-payment of rent. It also prohibits them from charging fees, penalties, or other charges to the tenant related to their non-payment of rent. So it also takes away their ability to charge late fees or any other fees that they might charge when a tenant is late. It also provides that those landlords in covered properties may not evict a tenant until the moratorium expires, except on 30 days notice, and that notice cannot be given until after the end of the moratorium period. So it both extends the time for notice. In most cases, a non-payment notice in Alabama is 7 days. The CARES Act for covered properties extends that time to 30. It does not affect cases that were filed prior to the date the moratorium took effect or after it sunsets. So if you filed an eviction prior to March 27th, March 26th or before, it's not covered by the CARES Act.
Now, I would say that I'm getting conflicting news
Yeah.
on that. I mean, I'm hearing the statute, like how limited the CARES Act is in terms of it's about 8 pages of housing legislation that completely upends the housing market. I'm hearing in some podcasts and from some apartment, like some organizations, that it might have an impact.
Yeah.
So it's kind of sort of throwing a dart at a board right now.
Oh yeah, it is in a lot of ways, and you'll hear us in a minute talk about covered properties and how that's like throwing a dart at a dartboard. We do know for sure that this thing sunsets on a date in the future, and we know that date. It's going to sunset 120 days after the act took effect on March 27th. Count out 120 days. That's July 25th of 2020. So that's when this thing will end. Obviously, I think we're all hoping that by the end of the summer, life is returning to normal. Our kids are returning to school, and the housing market will return to normal. But there is an option to extend this thing if that does not occur. The CARES Act doesn't cover non-covered tenancies. So in many cases for private landlord tenant, it may not have an effect and life will go on under the existing laws. It also doesn't cover evictions where the reason for eviction is anything other than non-payment of rent or non-payment of other fees or charges. So again, if you're violating other lease terms, if you are bringing in unauthorized occupants, if you have brought in an unauthorized cat, dog, alligator, now is not the time to be bringing in your emotional support chicken. Any of those things are still cause to evict, and the CARES Act does nothing to protect you in that case.
Next slide.
So here's where the rubber meets the road in the CARES Act, and where all of us are still kind of running blind. Like Sarah mentioned, this is 8 pages of legislation. You can go back and look at some of the notes from when it was argued in Congress. I'm going to give you information based off my reading of this act, based off Legal Services reading of this act, and based off the National Housing Law Project, which is basically the trade group for legal aid and other housing agencies on the public side, our interpretation of this act. As you can imagine, we're hearing very difficult and different things from groups like the National Apartment Association. I'm citing you the act, go read it yourself. It's very dry reading and it'll put you to sleep. The eviction moratorium applies to covered dwellings, which includes those dwellings on or in covered properties. The way this thing defines a covered property is if it participates in a covered housing program as defined by the Violence Against Women Act. That's the big umbrella that's causing a lot of problems. We believe that the inclusion of VAWA, the Violence Against Women Act, is basically meant to create this big federal umbrella so that they don't have to name out 28 programs that fall under VAWA by name that would be covered by this moratorium. Most notably, if your rent is in any way subsidized, if your rent is in any way based off your income, if your income goes up and your rent goes up, if your income goes down and your rent goes down, there is a good chance that you are in a VAWA eligible property and therefore, we believe, covered by the CARES Act. That's your public housing, that's your Section 8 housing, that's Section 8 project-based housing. So a lot of times that's an apartment complex that you consider income-based. You may not know you're on a Section 8 voucher, but that is technically how your rent is funded. Section 202, housing for the elderly. So a lot of your all senior apartment complexes, places you have to be over 60 to qualify to live in. Section 811, which is housing for people with disabilities, which is housing for people with disabilities, which is somewhat the same thing. If your rent is income-based and you are in a property that you had to be disabled to qualify to live in, chances are good it's paid through, subsidized through Section 811. LIHTC, which is low-income housing tax credits. These get iffy because many properties have a portion of the property that is LIHTC, a portion of the property that's not. If you've ever heard those stories about high rises in New York, where they're building multi-million-dollar condos and then 8 rent-affected units, that's LIHTC. That's part of how they're funding it. And the way that we read the CARES Act, that whole building is going to be covered under the CARES Act. I won't read you out the other 28 programs, but in general, if your rent is income-based, there's a very good chance you fall under these. If you qualify for your housing because of the homelessness prevention program, because of an AIDS-related housing program, all of those, we believe, fall under the CARES Act.
Well, that's not what the statute actually says. So you read the statute, and I think that if Congress wanted these programs to be included, they have the ability to list the programs that they want to have included. The idea that because some of the units or some of these programs are eligible for VAWA, that means all the programs are included in these protections, is a really broad reading not supported by the text. That being said, if you're a practitioner, you're going to want to practice as conservatively as possible, because the other thing the CARES Act does not do is provide any kind of idea what the penalty is for violating the eviction moratorium. So your guess is kind of as good as mine. To give you sort of an idea though, when Holly says, because she's about to get to a federally backed multifamily mortgage, certainly a lot of the CARES Act is designed to help those that are the most vulnerable. But in the North Alabama area, I sort of did a rough survey of my client base, and we're looking at about a quarter to 20% of multifamily mortgages having some kind of federal backing. The thing you would run into is it's not just the lower rent levels of the market. It's kind of stratified, where it's high end, high rent level properties, as well as sort of the lower idea. And a lot of times the properties don't even know if they have federal backing. So it's kind of a patchwork. And if you are a practitioner filing evictions, or you're dealing with a resident or a tenant trying to explain to them whether the moratorium applies, I agree with Holly that you should plead it as an affirmative defense, probably in every answer you're doing on behalf of tenants, to put the ball back in the landlord's court. But the thing you're running into is the sort of the legal services reading of the statute, if you read the statute, is not there.
And you could probably imagine that I respectfully disagree. And I think Sarah and I both remain hopeful that as we get more and more guidance from HUD and we see some of these letters coming out, that hopefully we will get a little bit more clarity on what these are. For the record, for any tenants that are living in those income-based properties like public housing or Section 8, their rent is already based off of their income. And so if their income changes, if you've got a client in public housing and they worked at, Belk, and Belk is now closed, it's a non-essential retailer, when their income dropped, their rent should drop right along with it. We are having some problems with, as we mentioned before, a lot of businesses are closed, but staff are present. That's certainly no different with a lot of landlords and housing authorities. And so that normal thing where you'd walk into the office and have a conversation isn't there. I'm telling clients to email where they can, to send a letter where they can, to make sure that those notices are given. And I know at least here in Huntsville, they're trying to have some hours where they remain open to talk with people as this comes in.
And I think that a lot of this, does the VAWA umbrella expand? It's academic, because we're never going to actually see an eviction where it matters because of that ability of a tenant to adjust their rent.
Yeah. The other wide umbrella, as Sarah mentioned, is if a property has a federally backed mortgage. So basically, if Uncle Sam gave you the money to build or maintain this building, Uncle Sam is coming in and saying, hey, you're going to have to do what I asked you to do with regard to these tenants in this situation. And so if your property was purchased on an FHA or other federal product, any kind of federal multifamily property loan, they are also going to be subject to the CARES moratorium. We don't expect tenants to know what kind of loan their landlord has. In some counties, Madison County, all of our probate records are online. It's pretty easy for me to go online, look up the documents and tell you if it's a Fannie or Freddie, but there's no federal database where somebody can Google that information up, and it's certainly not an easy thing to pull statewide. I would imagine that your run-of-the-mill apartment managers who are the agents who testify in court during an eviction trial are not going to have that information either. It's like asking my kids what kind of mortgage mommy has. So that's something to bear in mind, is that we're all going to have to learn together how to figure out what kind of loan a property has, and best practice for landlords may very well be getting that information signed from the client prior to filing.
And the thing you're also running into is federally backed. In what way, if it's serviced by, there's just no real guidance on exactly how expansive or how narrow this interpretation needs to be. And so unless your property in multifamily or single family, unless your rental property is paid for, now you should look at evictions as something that's a little bit more dicey.
Yeah.
Go to the next slide.
Yes, sir. So a few more general questions that have come up. A lot of tenants are asking, okay, well, I figured out how to make my rent, or I've talked with my landlord, but what about my utilities? Not a lot of good to have a roof over your head if nothing in it functions. Nearly all utility companies across the state right now have some kind of moratorium on shutting off utilities until a certain date in April. That date has varied around the state. The most common seems to be April 30th. Alabama Power has been somewhat lackadaisical in their policy, but they are telling us basically we're not going to shut off in the middle of this. I haven't seen a formal written policy, but admittedly, I don't live in an area where Alabama Power is the big player. Huntsville Utilities has kept their moratorium in place until April 30th. Decatur Utilities has done the same. As with everything else, I think communication is key. Many of these utilities, public utilities, are regulated by the Public Service Commission. The PSC has put out some guidance for them on whether or not moratoriums are appropriate, and I think the general feeling is that they are in the short term for the next 30 days or so while this is going on. That doesn't mean you don't owe your bill. Your bill is still due and owing. It just means that they're not going to shut you off during this period of time in which we're asking people to stay in the house. I'll leave some of this for Sarah, but the other questions we're getting from tenants are landlords that are refusing to come in and do repairs and maintenance. Obviously, that becomes a safety issue in a way that it's never really become before when we're telling people to shelter in place. Are we really going to send the maintenance man into 120 units to change out the air filters right now? Imagine the ability to spread disease that way. And so things are finding a new normal. The line that I have given tenants is if it is a repair that is needed to maintain habitability of your property. So certainly if your sanitary facilities aren't functioning, your toilet is not working, your septic system isn't working, your sewer line is backed up, you don't have your HVAC unit, although right now we're luckily in fairly temperate weather if you didn't have heat in the winter or air conditioning in the summer. If your electrical system is sparking, I think all of those things warrant a maintenance request that should be responded to promptly. If we're dealing with some of the more minor issues, hey, my carpet's coming up in this corner, or hey, my ceiling has a small leak, or hey, I need an air filter. Right now, I think it's appropriate for landlords to be limiting contact with those. Interested to hear what Sarah has to say.
So when this all started, it's sort of twofold, and I think Holly mentioned it. First, there's the risk that your maintenance man might be positive for the virus and runs around infecting the entire community, and you don't want that kind of liability. So I have gone to sort of an emergency work orders only kind of policy. I agree with habitability, that it has to be something that really makes it difficult to have the tenant reside in the property. This is not really the time that you want to worry about doing or finishing remodels that you might have been doing with the units. And it's also, you get into wonderful sort of fair housing territory, but I've told my clients it can be appropriate to ask if anyone in the household has tested positive, if there's been recent travel, but you need to contact an attorney and get some guidance on making sure that you do that consistently. Not just on certain people that might be in protected classes. If you're going to make that kind of inquiry, you should do so consistently. And then that also begs the question, what if it's an emergency and they answer that they might have been exposed? And that just becomes sort of a really interesting kind of question.
That you're not going to answer?
I'm not answering on film.
I mean, it's a terrifying question. What if you're in an upstairs unit and you've got a COVID-19 positive person in an upstairs unit that's flooding the downstairs unit?
And I've got COVID, like I've had 3 or 4 properties right now where people that are positive are living. And so it's just sort of an interesting kind of world right now.
Well, and it also begs the question, if, you know, what right does a neighbor have to know that their neighbor has tested positive in a multifamily property?
Yep.
And I do have one question, and it actually came to me a couple of days ago, and I wasn't able to give a good answer. There's a tenant living in a shared space with the landlord. Landlord lives upstairs and shares a common walkway, and it's a single family home, but they share it. And the landlord is positive for COVID. Tenant isn't, and tenant wants to move out. Is a landlord having a virus a health safety issue that a tenant can choose to move out of the house?
I mean, the thing you're into, and we're going to get to this then with the next one, what if my landlord tries a self-help eviction? Right now, a lot of things have changed, but the Landlord Tenant Act has not. So if the tenant feels that he is being exposed to a health and safety related issue, the remedy is a notice and an opportunity to cure. I mean, there's nothing else in there. Now, if I was the landlord and I was positive and my tenant wanted to move, I mean, would I advise my client to let the tenant go? Absolutely. Like, yes, there are still contracts. Yes, rent is still due. Absolutely. But at the same time, at some point, the courts are going to reopen and we're going to figure out what the right answer was. And so I am telling people to be sort of as conservative as possible in their interpretations of the CARES Act and if they're covered. And just as, this is not the time to say, you signed the contract, you must have strict adherence. I will not, rent is due, late fees on this day. This is not that time.
So one of the unfortunate problems that has run out of this are landlords attempting self-help evictions. These, much like we've said, the act still applies. Nothing about COVID-19 has made the Alabama Landlord Tenant Act inactive. Self-help evictions are prohibited under our act if a landlord attempts them. They can be sued for up to 3 times the monthly rent or actual damages, whichever is higher. You can also, and this is one of the few chunks of the act where you can get this, get reasonable attorney's fees. And we do sue for attorney's fees on these at Legal Services every time we do them.
I always wonder where those go.
The things the federal government won't let us pay for, exotic luxuries like dry erase markers. Self-help evictions, the most common are changing the locks, lockouts, utility shutoffs. Most landlords are not stupid enough to create a paper trail of shutting it off directly through the utility company. So they'll go out to a breaker box, or they'll go out to the water main and shut it off with a utility key. We've had some inventive landlords over the year decide, oh, well, I can't deny them access. Well, I'll just take the front door off the hinges. That way I've given them complete access. Meanwhile, your home is unsafe and really unlivable if the door is off the freaking hinges.
I will say I have in 15 years, I've only had that happen once. I mean.
Someone take the door off?
Yeah.
It happens at least once or twice a year.
Really?
Yeah. Not in Sarah Taggart properties. maybe that's because you have Saratoga properties, and then we have some people in Coleman and Marshall County.
And I will say, the most common areas in which these come up tend to be pro se landlords, smaller landlords, landlords who have never thought of calling an attorney and kind of believe I am the law because I own 123 ABC Street. But if a landlord tries a self-help eviction, at least my luck on these has been, this is something you can file for injunctive relief on. This is something where you can certainly call the landlord, put the fear of God in them, put on that mean lawyer voice that my husband and children had never heard before we started working from home. And they still don't quite know how that comes out of my body. My 11-year-old son was like, that person's in trouble, are you gonna grill? You certainly can call those landlords. You certainly, if they are not responsive to a phone call, have the ability to file for injunctive relief. Most of our counties have given out an emergency number for the judge on call, or they've just said, call the presiding judge at this number. We believe that these are emergency cases. Our judges so far have felt that these are emergency cases, and they are allowing petitions for injunctive relief and allowing these to be served and move forward as emergency cases, same as protection from abuse orders, elder protection from abuse orders, things like that that are still being handled despite the court closure. I think our courts recognize that people who have nowhere to stay in the middle of this are incredibly vulnerable. I know here in Madison County, I sat on a conference call this week where our homeless shelters are basically at or over capacity. We are turning people away in a way that we've never done before. So an illegal eviction in the middle of this can very well be a death sentence. And so our courts are taking that incredibly seriously.
Well, and we have a number of questions whenever.
Well, we do. It is only supposed to be an hour.
Right, yeah.
We need to move.
Okay.
I'll hold the questions to the end, but know that there are 5 or 6 questions whenever you're.
All right. What will happen to my eviction? This is the sort of the common questions I'm getting. I have 3 German Shepherds and a co-working partner, and so I pace my sidewalk on the phone all day answering the same questions. I walked 11 miles yesterday. What will happen to my eviction filings that were already in progress? Generally speaking, I have no inside information to what's going to happen and how they're going to sort of restart these dockets. I imagine it is going to be incredibly not just county specific, but judge specific. You know, some judges might add dockets. CARES Act, you know, some people that are analyzing it say that if your property is subject to it and you don't have an order, that you can't move forward. Others are saying if it was filed before the CARES Act, it is not subject to the CARES Act, don't worry, move forward. Again, the answers are pretty vague. Hopefully we'll get some more guidance from the federal government before we answer that. But generally speaking, your evictions that are already in progress, especially if they're not subject to the CARES Act, will move forward once we get in-person hearings. Now, some states, when they reopen the court system, have reopened the court system except to landlord-tenant related issues. I don't know what the Alabama Supreme Court is going to do and how they're going to look at reopening, but that is something to keep in mind. Can I put up late notices on April the 6th? Most leases are rent is due on the 1st, late on the 5th. 7 business day notices at your more sort of aggressively collecting properties usually go up on the 6th or 7th. If you are subject to the CARES Act, if your property has a federally backed multifamily loan, or if you are a single family landlord and you have a federally backed loan, then no, do not put up late notices. You cannot put up late notices. There are ways to try and encourage on-time payments, but your 7-day notice to pay or quit, your 7-day notice for someone to vacate, which is what a 7-day notice for failure to pay rent is a notice to vacate, does not need to go up like it usually does. What about incremental rent increases at the expiration of the lease and month-to-month fees? So you have, if you are subject to the CARES Act, this is also not a time to add, to do a non-renewal or to do an, add your extra month-to-month fees that might be provided for in the contract. But if you're subject to the CARES Act, this is probably not that time. Are you forced to renew leases that you had no plan to renew? Again, if you're subject to the CARES Act, what I'm telling people is just let them go month to month. Once this all blows over and the act sunsets, then we can talk about issuing a non-renewal. But even if somebody's lease expires right now and they don't move out, well, technically speaking, under the Landlord Tenant Act, they're a holdover. I can evict them for being a holdover. But if I file the eviction, even if I can get it served before shelter in place goes into effect in this part of the state, it's not really moving anywhere. So this is kind of the time that I've been telling my clients, just take a deep breath. Rent has just become due. We don't know what kind of delinquencies we're looking at. So let's just pause and see where we are, especially once Congress gets back in session. I'm sure we'll get some kind of clarification. Next slide. What protections can I put in place to safeguard my employees? If you are multifamily, the leasing office should be closed. It should be closed to the public. This is not time to have all your residents coming through your leasing office and exposing your employees to risk. Also, as we spoke earlier, emergency work orders only. You need to discuss sanitation with your maintenance workers. Hopefully you can find hand sanitizer to provide them, and you can find soap to provide them, but you want to make sure that they're practicing good sort of personal hygiene to try and make sure that their risk is lessened. You also want to look at, if you're multifamily, closing your amenities, close your gym, close your barbecue area, close your pool, close all of those down, because the gym especially is just not a really good place to have available to residents in a pandemic. Also, it's arguable that KIV's order closing the gyms would apply to your amenity of the gym. If we go shelter in place, is a housing provider considered essential? Now, all of the different shelter in place orders that have been issued for all of the different states say something a little bit different. So it's really going to depend on what Governor Ivey does and what she includes when and if we go to shelter in place. In most states, housing providers have been deemed essential. Just for the very real point that Holly addressed earlier, if we have a sanitation, hot water heater explode, leak, this impacts the tenant's ability to shelter in place. So at least your person responsible for maintenance and your person responsible for collecting payments, because a landlord, even with these mortgage forbearances, the note on the multifamily property is just one of the expenses associated with providing services as a landlord. So the person that processes payments and helps people with payment plans could also be deemed essential, because that keeps your payroll going. Next. Go ahead.
Since we're focusing on landlord tenant today, I just wanted to give a very brief mention of foreclosures and mortgages in this context. As Sarah mentioned, many multifamily properties that have these federally backed mortgages are going to be subject to a moratorium on their payments for a brief period of time, or for some mortgage relief. The same is true for individual borrowers. If you have a federally backed mortgage on your house, if you're a homeowner, if you have an FHA, Fannie Mae, or Freddie Mac loan, they're currently subject to foreclosure and ejectment, which is a post-foreclosure eviction. Moratoriums for 60 days, so that's going to last out until May 18th. If you are an FHA mortgagee, so you have an FHA loan on your home, those are eligible for a 6-month forbearance. That's from a HUD letter that came out 2 days ago. If you can prove that your hardship was COVID-19 related, time will tell if this will be as hard as getting mortgage relief for borrowers was in 2008 at the Great Recession. But right now we are seeing these programs open up. We're being told to expect USDA and VA guidance at the beginning of the week for those federally backed products too. But that's just a brief side note as it affects individual homeowners and sometimes those landlords that are renting out a property that may have a federally backed loan. Those are going to be subject to some relief.
Okay, you guys ready for your questions?
I mean, yeah, sure.
Okay, let's see. Oh, someone says that the section 4024A2 of the CARES Act is the part where the VAWA language is, if anyone wants to read it. Student leases, if they're based on like college residency, are they automatically voided as acts of God, frustration of purpose, or would students still owe the money on their leases?
It depends on how the lease is written. I get this a lot because a lot of commercial properties have clauses in there that if there's sort of a natural disaster, you know, something impacting the ability of the business to open or run, that there's a terminable clause in the lease. The lease can just, you know, go away. It's not so much in residential leases. I have not seen, I've been looking, a clause that would say or address what happens in a pandemic or what happens in a natural disaster. You know, leases always do have buyout provisions. The thing that you run into is most student housing receives federal funding, so they're going to be subject to the CARES Act. It's really going to sort of depend on how you want to advise your clients. Again, I'm telling everyone to practice as conservatively as possible because we don't still even know what happens if you violate the CARES Act. So it's kind of hard to give them good advice. At some point in time, we'll have answers. Until you have guidance, you need to try and err on the side of caution. It's just sort of how I practice. I know a lot of some landlord attorneys are a little bit more aggressive on that.
If I'm covered by the moratorium, is my rent forgiven?
No. If you are covered by the moratorium, your rent is not forgiven. Your rent is still due and owing. So when we get to the end of this thing on July 26th, 2020, that rent is still going to be due and owing. All the moratorium means is that they can't evict you for non-payment of rent right now. Doesn't mean that on July 26th, if you're still due and owing, that they can't sue you for the unpaid rent, sue you to kick you out, sue you for, you know, the ability to get their unit back.
So what's going to happen is July 25th, everybody's going to put up a 30-day notice to pay rent or vacate, but it's going to be April, May, June, July with a cure right. But who's going to, if you haven't been at least, I think the best advice I actually heard was from Huntsville Utilities that says, you know, pay what you can. Don't get in a hole too deep to get out of. There's nothing in any statute, any moratorium in any state that says rent is not due. There are certainly some states that are offering rent assistance and by sort of government action, but nobody's saying the contract is not valid.
One person says that all the housing cases they had in Calhoun involving properties, even where the writ's already been issued, have been stayed. So
it's just sort of a patchwork, and you don't know until you try.
Yeah. 2 questions left. Number 1, and this one is interesting. I think it's going to be for Sarah. How does fair housing apply to the COVID-19 crisis? If you select in terms of if you only waive late fees for COVID-19, but not for other types of disasters or problems, such as death or sickness, couldn't you be couldn't that violate fair housing because you're electing to sometimes waive them but not other times?
I mean, so you need to realize that fair housing only applies to discriminatory acts against protected classes. So you're really going to have to ask yourself what protected class this would fall into for them to even sort of claim that you're making a discriminatory action. You know, I think the better or a bigger fair housing obstacle is going to be if you only go to people who are Chinese and ask them about their COVID-19 status, because you know that's national origin. I've heard, you know, especially in South Alabama where there's a lot of hurricanes, that people are like, why should we do something different this time? There's natural disasters all the time. Why should anything change? Why should we do payment plans now when we don't do payment plans then? And again, there's no real guidance on that. But to speak to a bigger fair housing issue, I was in the middle of defending 3 or 4 fair housing complaints, and my fair housing investigators have just gone dark on me. Like, I don't know if they're working right now or if they're what they're doing. So you need to realize though that the CARES Act, I think, gave $2.5 million to fair housing defense. So, or no, to fair housing prosecution rather. So you're gonna see a spike in complaints, I'm sure.
We have very little time, so within 2 minutes, and I imagine you might have exactly the opposite answers. Who has the burden of proving whether or not the landlord is covered by the CARES Act? Who has the burden of proving whether or not it's a federally backed mortgage or whatever?
I argue that it's an affirmative defense.
And it would make it whose burden?
It'd be it would be something pled by the tenant's attorney. So there's an argument that they're going to add it to the e-filing form to make sure that landlord's attorneys have checked. Like, there's an argument that they're going to just add it as a box, just like, especially before we default, or part of it like the owner's affidavit. The way I think I read the statute is I file, she pleads as affirmative defense. I have to answer that like no, and it's going to be a pain.
So
my answer is going to be that it's the landlord's responsibility before they initiate litigation. We live in a state with the Litigation Accountability Act, that they should know who their mortgage holder is, because that's a hell of a lot easier for them to know than it is for a tenant to know or otherwise find out. I can drive down my street and I can't tell you who my neighbor's mortgage companies are. I guess I could go do a probate search and have a real good idea. But I think that burden much more easily falls on the plaintiff. And I think as part of litigation accountability, they have the duty to figure it out before filing.
Well, I think that we made the whole thing without anyone threatening a Litigation Accountability Act claim, and she like right in the wire.
I think in the statute it says it's I'm pretty sure that it's even the NHLP says it's an affirmative defense. So I think that Holly's reaching there. But I will say, in terms of how I'm going to move forward, or how I've moved forward on the evictions that I've filed since the 27th, I've done a good faith search. I've had my clients affirm that they don't have one after I've explained exactly what it is. So I have a piece of paper in my hand that says that they have done their digging and they don't have one. But in a lot of cases, depending on how expansively they read federally backed mortgage, I can tell you if they have a Fannie, if they have a Freddie, if there's a Section 8 voucher, if there's, any kind of income-based assistance. But if they read federally backed mortgage more expansively, I don't think even the landlord is going to be able to tell.
Okay, well, and we are at 1 o'clock, so thank you, Sarah. Thank you, Holly. And we will leave it at that. Appreciate you guys being here. If anyone has any questions, you can always email them to me, and I will give it to probably both of them, so you can get both answers.
So your last slide has our contact info.
Oh, and there you go. And so, and again, I will make sure to set these slides out. I didn't put them in the download box on the menu like we normally do. So thank everyone for attending, and good luck out there. Have a good afternoon, everyone.